Well, thank you all for coming. I can see that people are sort of joining at quite a steady pace, but I'm just going to introduce it. Welcome to the inaugural Foundry Chambers lecture series, I should say. We are going to start today with a talk from John McGuinness and James Gwatkin on sexual harm prevention orders and when they should and should not be imposed. And then David Smith is going to talk us through the rather detailed and quite complicated sentencing guidelines on firearms and other prohibited weapons. I can see everyone has put themselves on mute already, and for that I'm extremely grateful. And I'm now going to hand over to James and John.
Good evening, everybody. I'm sure everybody's been staring at their clocks waiting for this seminar on sexual harm prevention orders and sexual offences prevention orders to start. So the not so glamorous world of SOPOs, as I'll call them, and SHPOs have unfortunately become a quagmire of mistakes. Many of the cases have appeared before the appeal courts for a variety of reasons, but mainly grouped into three areas. So where orders have been made where a first instant court has had no jurisdiction to make an order, orders and conditions being imposed which did not fulfill the statutory test for the imposition of such conditions and orders, and finally orders being made in defective forms. And part of the reasons for the issues that have arisen is due to a combination of an unhelpfully complicated statutory regime, and also these orders, like many ancillary orders, becoming somewhat of a rushed afterthought as part of a sentencing exercise with insufficient detail and attention paid to them by practitioners and judges. So what this short talk aims to do is to demystify the process. So I'm firstly going to speak about the statutory regime for such orders and where things went wrong, and provide what I think are some of the key points for solicitors and advocates to look out for to avoid many of the pitfalls that have happened. Then John McGuinness will explain what happened in the case of Rowlett, which we were instructed in, which recently went to the Court of Appeal, and how the court resolved the issues that had arisen. There's a handout which is going to be uploaded, so with the statutory references and the case references, so don't feel the need to make any notes. In terms of the chronology of statutes, so on the 1st of May of 2004, sexual offences prevention orders, or SOPOs, were introduced as ancillary orders as part of the commencement date of the Sexual Offences Act 2003. And there are two main requirements for the making of a SOPO on conviction. The first was that a qualifying offence under Schedule 3 or 5 of the Sexual Offences Act had to have been committed, or the defendant would have to be found not guilty by reason of insanity, but the court found that the defendant had done the act as charged. And the second requirement was that the court is satisfied that the order was necessary for protecting the public or any particular members of the public from serious sexual harm from the defendant. And between 2004 and March 2015, section 104 to 113 of the Act govern the making, variation and renewals of discharges of SOPOs. It's worth mentioning at this point that the test for the variation of such orders was essentially the same for making the orders, i.e. that further prohibitions could be made if necessary for the purpose of protecting the public from serious sexual harm. On the 8th of March of 2015, sexual harm prevention orders, or SHPOs, effectively replaced SOPOs for new orders that were going to be made on conviction. The major change, other than the name, was that as well as the requirement that a qualifying offence had to be committed under Schedule 3 or 5 of the Sexual Offences Act, the court had to be satisfied that the order was necessary to protect the public from sexual harm from the defendant. So there was a lower threshold required from 2015. One would think, indeed many did believe, that any existing SOPOs that existed before the 8th of March 2015 would simply transform into SHPOs. However, as a result of Section 114 of the Antisocial Behaviour, Crime and Policing Act, this wasn't the case, and any existing orders stayed as SOPOs until 5 years after the commencement of the 2014 Act. And therefore the power to vary such orders was kept in place as per the higher threshold test, i.e. that the variation would be required for the purpose of protecting the public from serious sexual harm. On the 8th of March 2020, all SOPOs are converted into SHPOs by the operation of law, and therefore the issues with the transitional provision should go away. And for all purposes, existing SOPOs are treated as SHPOs, and therefore the variation and breaches of such orders fall under the same legislation as SHPOs. From the 1st of December of 2020, content with giving practitioners just under 9 months to adjust from the change from SOPOs to SHPOs, new SHPOs are now governed by the Sentencing Act. So the relevant sections of 343 to 358 of the Sentencing Act, which mimic the Sexual Offences Act sections. In terms of the errors made, the case law mainly falls into 3 separate areas. So firstly, orders being made where qualifying offences weren't committed. So the case of Hamer of 2017, the Court of Appeal, provides a good example of this. So the defendant was subject to a SOPO and breached it. And on conviction, the Crown Court judge purported to transform the SOPO into a SHPO. However, the breach of a sexual offences prevention order is not a qualifying offence for the making of a sexual harm prevention order. And further, there's no provision which allows for the conversion of a sexual offences prevention order into a sexual harm prevention order. So therefore, the Court of Appeal quashed the SHPO that had been unlawfully made. What could have been done was the variation of the SOPO. And indeed, this is what the Crown invited the Court of Appeal to do on appeal, pointing to the fact that this was clearly what the Crown Court judge intended to do. However, the Court of Appeal rejected this because of the form of the application. And this moves on to the second issue that has arisen, and that's errors in the form of the application. Variations of both orders, so SOPOs and now SHPOs, can only be applied for by the Chief Constable of Police for the area in which the index offence took place, or where the offender lives, or the defendant, as per the relevant sections of the legislation. So therefore, crucially, this means that the CPS are not permitted to make an application for variation, either as a standalone application or following the conviction of a new offence. The Court of Appeal in Hamer and the more recent case of Ashford in 2020 confirmed that only parties entitled to make a valid application was a necessary requirement for the application to be made. And therefore in Hamer, because no variation application had been made by the Chief Constable of Police, this meant that the court refused to vary the order as the Crown wanted it to do. It's also a requirement that these applications are made in accordance with the rules of court, which are obviously the criminal procedure rules. However, the Court of Appeal have taken a much more flexible view of this point which arose in the case of Rowlett, which John will talk about shortly. In terms of other errors, they include Crown Courts erroneously varying orders which were made in magistrates' courts, which are not permitted by the Act, and of course making conditions which were not necessary or proportionate to the relevant circumstances of individual cases. So in terms of what I think are the main areas that solicitors and practitioners should think about when dealing with these applications, is firstly to check whether the court has the jurisdiction to make the order. So check that the defendant has been convicted of an offence which does allow for the making of a SHPO. Some offences, somewhat surprisingly, can lead to the making of such an order, such as theft. However, other offences, such as the breach of an existing sexual harm prevention order, does not provide the grounds to make a new one, albeit it may provide the grounds for variation of such an order. Other offences may provide the grounds for making of a SHPO, but only if the defendant receives a certain sentence. So, for example, convictions for indecent images of children, either under the 1978 Act or the 1988 Act, are only a qualifying conviction if the persons in the images are under the age of 16 and the sentence is at least of 12 months imprisonment. So if somebody was to receive an order, a community order, or a sentence under 12 months of imprisonment, that doesn't lead necessarily to a sexual harm prevention order on that conviction alone. The second point is to ensure that the tests for making these orders are applied. So is the order necessary to protect the public from sexual harm? In many cases involving serious sexual offences, whether committed against adults or children which were committed recently, obviously if you're defending, you're going to be facing an uphill battle, because the basis for making a SHPO will be fairly strong on the basis of the conviction being made. But nevertheless, not all conditions will be appropriate. So therefore, the circumstances of the case are important. However, in cases where the offences are historic, or in images cases, the proposed conditions, and indeed whether an order is necessary at all, should be scrutinised and challenged where appropriate. So quite often one will encounter pro forma applications drafted by police which prohibit all contact with children under the age of 16 and place heavy restrictions on internet-capable devices, which may be appropriate in certain cases, but not in others. So the Court of Appeal in several cases, such as Smith and others in 2011, and also Parsons and others in 2017, have emphasised that these orders are serious orders, placing restrictions on liberty, and therefore the conditions need to be sufficiently nuanced and clear to fit around the circumstances of each case. And finally, a way to avoid both of these issues is to ensure that applications are drafted and served in advance of hearings in accordance with the criminal procedure rules, and with all parties therefore able to consider and take instructions where necessary. And the issues which have arisen in most of the appeal cases is that the applications were brought up at the first time in the sentencing hearing, which inevitably leads to mistakes in quite a complicated area of law. And finally, in breach cases, make sure that the original order was correctly made, and if it wasn't, challenge it, which is, if you're defending at least, which is what happened in our case. And I'll now let John tell you about what happened in the case of Rowlett.
Unmuted? Great. Mr. Rowlett had been convicted in 2012 of raping a child under the age of 16, and was made the subject of a sexual offences prevention order prohibiting him from being in the company of females under 16 without parental supervision. So for as long as he was serving his sentence, not a problem. He was then released in 2017, still subject to the SOPO in the somewhat simple and limited terms in which it had been made. Unfortunately, on his release in 2017, the defendant started to take an interest in communications of a sexual nature with underage females. And when he was visited by his supervising officer, he handed over his mobile telephone. And when she downloaded it, she saw material on it which indicated that despite the terms of the SOPO, he was intending to communicate, make communications of a sexual nature with females under the age of 16. She therefore decided to go back to the Crown Court, which had made the original SOPO, ostensibly to get the terms of the original SOPO extended. Not a problem, because the Act provided for variation of the terms of a SOPO. That, of course, requires an application to be made. This was an application made by the police because it wasn't being suggested that Mr. Rowlett had committed any additional offences. So there was no question of prosecuting him, bringing him to court, getting him convicted, and then because he was convicted, getting some other form of order with more limiting conditions imposed. The police decided to use the existing provisions, as it were, to beef up the terms of the SOPO. Not a problem with that. They were entitled to do it. And they made an application. They got off to a good start on the application because the application was headed application for variation of a SOPO, which was the right thing to ask for. However, from that point on, things became procedurally much more bad for the police. Having applied to vary a SOPO, good. The application then said the application to vary was being made under the wrong section of the Sexual Offences Act and was in fact being made under the section of the Sexual Offences Act that allows you to vary a SHPO. So that was the first mistake that was made. The second mistake that was made was that the statutory test, which had to be set out in the application for the variation, set out the statutory test for the variation of a SHPO and not a SOPO. As James has explained, the test for a SOPO is higher, a risk of serious sexual harm, as opposed to a risk of sexual harm for a SHPO. So that was the second error that was made. When the hearing came before the judge, the parties had agreed the variation and the terms of the variation, but obviously that still required the order to be made by the judge. So it wasn't simply enough that the parties had got their heads together and said, this is what we agree. The matter was placed before the judge, who, whether it was a SOPO or a SHPO, had to be satisfied of the relevant statutory test, which, as it was, could only be an application to vary a SOPO. He had to be satisfied that there was a significant risk of serious sexual harm. In his brief judgment, the judge did indicate that he was satisfied that there was, to use his words, a significant risk to young females, but then didn't go on to specify a significant risk of what. So he specified neither a significant risk of sexual harm nor a significant risk of serious sexual harm. So he didn't apply, frankly, any test at all. He then, in the course of his judgment, purported to turn the SOPO into a SHPO, which he couldn't do. And the written order that came out from the court as a result of this application came out as a SHPO, which was wrong. And in any event, even if he could have made a SHPO, he couldn't, in fact, made a SHPO because no qualifying offence had been committed, and he had no power to convert the SOPO into a SHPO. So it was, on any view, a bit of a dog's dinner. Neither counsel for the applicant nor counsel for the defendant, nor indeed the judge at the time, realized that he'd been asked to do something that he couldn't do. But in any event, that's what happened. And for the next 3 years, Mr. Rowlett was blithely subject to an order that had no proper legal basis until he got himself into trouble again and ended up being prosecuted for breaching the extended terms of the order that had been made in 2017. He was represented by James, who went back to the court appearance in 2012 and went back to what had happened in 2017. And it was James who spotted that the application before the judge in 2017 had been a bit of a dog's dinner. And therefore took the point that it didn't seem right that Mr. Rowlett should be convicted of breaching an order because he was being accused of breaching the extended terms of the order. James took the point that he shouldn't be convicted of breaching the terms of an order which had not lawfully been made in the first place. So he applied for leave to appeal out of time on the basis that the order was inherently bad. He got leave to appeal out of time. We ended up going before the Court of Appeal with essentially 3 arguments. The first was that because we argued the Crown Court had no jurisdiction to make the order that it had made, then applying the terms of Section 11.3 of the Criminal Appeal Act, the Court of Appeal, which would have had jurisdiction to have made an order that the Crown Court could have made, couldn't put things right. Our first argument being that the Crown Court had no jurisdiction to make the varied SOPO at all because of the various defects in the process. If we lost on that, our second argument was that even if the Court of Appeal could vary the order that had been made in 2017, Section 11.3 gives it a discretion to do so, and in all the circumstances, it ought not to do so, principally because the judge, 1, didn't address himself to any test at all, and 2, in order to make the order that he did make, he would have had to have been satisfied of the relevant risk of serious harm, because it was a SOPO, as opposed to the lesser risk of just a risk of sexual harm. So we said for that reason, the court ought to exercise its discretion not to replace the order. If we failed on that as well, our third argument was looking at the terms of Section 29.4 of the Criminal Appeal Act. The court, if it decides to substitute one order that could have been made for another order, can say that it will start with effect from the time that the Crown Court judge could have made it but didn't, or from the date on which the Court of Appeal made it. So our third argument was, if you're against us on 1 and 2, then on argument number 3, if you are going to impose the correct order, it should only be imposed with effect from the date of the Court of Appeal ruling, which of course would have meant that Mr. Rowlett would have had a complete defence to all the allegations of breaches. The Court of Appeal, in its inimitable way, dismissed all of our arguments, holding on the jurisdiction point that the Crown Court judge did have power to make a SOPO, and therefore the Court of Appeal had power to make the order that he could have made, on the basis that if the order had been properly worded, i.e. a true application to vary a SOPO, in other words, had everybody spotted the mistake at the time, there's no reason why the application couldn't have been amended so that it was a proper application for a SOPO. Our reliance on the case of Hamer was distinguished because in Hamer, the court held that the person making the application had no locus to make the application, whereas here the application was being made by the chief constable. And therefore the court took the view, applying a liberal interpretation to the criminal procedure rules, that all could have been put right if everybody had thought of it at the time. As far as our second point was concerned, which was that the court should exercise its discretion not substitute the correct order because the Crown Court judge had not given any consideration at all to the proper statutory test. Court of Appeal did what it sometimes does, which says the evidence was absolutely overwhelming, given the download of the phone that he'd handed over to his supervision officer, and that if the correct test had been applied at the time, which it wasn't, the correct test would have been satisfied. So the court held that it was fair that the order should be substituted. Our third argument, which was the timing point, that if the court was going to put things right, it should only put things right with effect from the date of the Court of Appeal order, was also dismissed, the court taking the view that Mr. Rowlett had spent the last 3 years believing that he was subject to a proper order and therefore should have conducted himself accordingly. And the fact that it was alleged he hadn't conducted himself accordingly because he was in breach was not a reason for the court to make the order start from the later date. The only SOP that we got from the court was that it felt that the terms of the order that had been made by the judge in 2017 was in fact too extensive because Mr. Rowlett's interest was in females under the age of 16, whereas the terms of the order prevented him being in the company of anybody under the age of 16. And therefore it did substitute the order, but with slightly different terms to make it plain that Mr. Rowlett's restriction was on being in the company of females under the appropriate age. And therefore the appeal was allowed by means of the quashing of the order that had been made. And due to the passage of time, SOPOs had been abolished in any event. You can't make a SOPO after March 2015, but there was a 5-year period where SOPOs carried on being in existence in tandem with SHPOs, which came into effect in 2015. In March of last year, by virtue of operation of law, all SOPOs were converted automatically into SHPOs. So the end result, ironically, was that our argument being that the judge had made a SHPO that he had no power to make, the Court of Appeal's end result was to impose a SHPO because it can no longer impose a SOPO since last year. And the case is interesting because it illustrates that the court can use the relevant provisions of the Criminal Appeal Act essentially to do what it wants. David. David?
David, you're muted.
Won't do that. Right, okay. I think that's done it. Can everybody hear me okay? No. Right, can you wave your hands if you can hear me? Hey, marvelous. Okay, good evening, everyone. I see a lot of very familiar faces in the meeting and some not so familiar to me. And this talk is going to be accessible on video on the Chamber's website after tonight. So perhaps I better introduce myself to those who don't already know me. I'm David Smith, and I am going to talk about the new firearms guidelines which were issued in 2021. I'm going to have to ask Jess Tate, if she's administering this, to give me access to screen share in about 10 minutes. So perhaps you could bear that in mind. But first, 2 personal apologies from me in advance. Sorry if I refer to you as members of the jury, but old habits die hard, and I found myself lapsing into that quite regularly while I was running through this earlier today. And I have been asked to speak for 30 minutes. Those of you who know me, I see smirking because you know I'm going to, there's a risk that I may easily speak for double that. So if Jackie Weaver's watching, can I ask you please to lock me out of the Zoom in 30 minutes, please? And for the sake of complete satire, you will notice that I am not a cat. Now, in truth, this is an extensive topic, and we will only be scratching the surface in this talk tonight. But the main thing is that you go away after this evening and you have a read of these guidelines and familiarise yourself with the digital process that it entails. The online nature of the guidelines mean that there are drop-down menus which can be confusing at first glance, and ultimately I have found that they are far more helpful than in fact thumbing through Archbold or Thomas. The possession and use of firearms are controlled by no less than 35 statutes and numerous pieces of secondary legislation, even though we all refer to the Firearms Act 1968 as amended. Now, anyone who has tried to read through chapter 24 of Archbold will find it an anxiety-inducing cornucopia of information, particularly if they are lucky recipients of a late return. And these are complex offences, and while low in volume, can be extremely serious, with several offences carrying maximum sentences of 10 years or indeed life imprisonment, and some requiring a minimum custodial term to be imposed. So any practitioner wanting to know the maximum sentence for a firearms offence traditionally would have to trawl through Archbold for this information. That is not an exercise which I have found to be particularly easy. But over the last 23 years, any advocate either drawing up a sentencing note for a court or indeed making a plea mitigation will have referred to the sentencing judge, or should I say referred to the sentencing judge, Freudian slip, will have been referred the judge to the Crown and Avis, and in the last 10 years, Sheen and Sheen. The court would have to address 6 questions under the old authorities, as you will no doubt recall. What sort of weapon was involved, and by implication a firearm which had no lawful use, such as a sawn-off shotgun, is more serious than possessing a firearm capable of lawful use. What use, if any, was made of the firearm? What was the intention of any that the defendant had in possessing the firearm? The court would be required to look at the defendant's record, where a firearm was discharged. It would be looking at who and how many people were exposed to the danger in its use. And the court would have to ask if any injury or damage was caused by its discharge, and if so, how serious was it? So, save for minor infringements, the court in Avis said that offences generally merited custodial sentences, even on a plea of guilty, and when the offender had no previous record. Now, where answers to any of those 6 questions were adverse to a defendant, the custodial term was likely to be considerable, at or approaching the statutory maximum following a contested hearing. And there was one further qualification in January of 2004. Most of the offences under section 5.1, where the offender was 16 or over at the time of the commission of the offence, and section 5.1 capital A, became subject to the minimum sentence, the mandatory minimum sentence, the 51A as it was called. And those sort of offences include possessing a firearm with intent to injure, with intent to cause fear of violence, with criminal intent in a public place, and so on and so forth. And that meant a minimum 5-year custodial term for an offender aged 18 or over at the time of the offence, and a minimum 3-year custodial term for an offender under the age of 18 at the time. I qualify that because if an offender was under 16 at the time of the offence, the minimum term provisions did not apply to that offender. And I should also say that if charged as a conspiracy, the minimum mandatory sentence did not apply either. Now, a court cannot pass a custodial sentence below the appropriate minimum term unless the court is of the opinion that there are exceptional circumstances relating to the offence or to the offender which justify not imposing the minimum term. That's clearly set out in section 51A subsection 2. And this means no reduction below the minimum sentence to reflect credit for a guilty plea. Now, following a consultation, the Sentencing Council has issued no less than 8 new guidelines for sentencing offenders convicted of firearms offences. And these, as you all know, came into force for defendants falling to be sentenced on or after the 1st of January 2021. So anyone from tomorrow onwards is going to be sentenced by in accordance with these issued guidelines. And it almost goes without saying that the maximum punishment for each firearms offence hasn't altered. And perhaps it serves to remember that offences such as possessing a firearm or ammunition by a person who is prohibited by virtue of conviction would attract up to a 5-year sentence. Purchasing or possession or the acquisition of firearms or ammunition, or indeed a shotgun without a certificate, carries up to 7 years, depending on the type of offence, as does carrying a firearm in a public place. Then things start hotting up, and possessing of a firearm or an imitation with intent to cause fear of violence, so the section 16A, carries 10 years imprisonment, and a possession with intent to endanger life, of course, section 16 carries life, as does the use of a firearm or an imitation in order to resist arrest or to carry out a Schedule 1 offence, or being carried simply with criminal intent, section 17. So these sentences can very quickly rack up. Now, up to the beginning of the year, the only guideline issued by the Sentencing Council was for use by magistrates' courts, and it only covered offences of carrying a firearm in a public place. Quite extraordinary, really. The expectation of the Council in drawing up these guidelines is to ensure that a consistent approach is taken to sentencing these offences, and will make the sentencing process more transparent and easy to understand for victims, for witnesses, the general public, I might add the legal profession, and dare I say it, the judiciary. Now, there has been some acknowledgement, which is something of a new departure, but something of an acknowledgement of disparity in sentencing. And there has been something of a subtle change in approach in this regard. Now, in drawing up the guidelines, the Council took notice of the findings of the Lammy Review, that headed up by David Lammy, the Tottenham MP, and current, and in fact has been Shadow Secretary of State for Justice and Shadow Lord Chancellor under Keir Starmer's Shadow Cabinet. Now, that reported in 2017, and it was taken on board by the Sentencing Council. This report drew attention to evidence of sentencing disparities in specific offences as an integral part of the sentencing process. And the overall finding was that Black, Asian and minority ethnic offenders were dealt with more severely for firearms offences than white offenders. Now, the Council also noted that ethnicity was not always noted, and that features of individual cases were not taken into account. We will all have appreciated and experienced the reticence, for example, of judges to order pre-sentence reports, particularly where there is a cost implication, where there is going to be an inevitable custodial sentence. But the fact that these are not regularly being ordered in this sort of case has meant that much more important information is not being taken into account by a sentencing tribunal because of a lack of awareness of the individual circumstances of those from Black, Asian and minority ethnic communities. So the new guidelines specifically direct judges to sections 123 to 129 of Chapter 8 of the Equal Treatment Bench Book. That's the chapter entitled Racism, Cultural Ethnic Differences, Anti-Semitism and Islamophobia. So I would strongly recommend that after this talk at some point at your convenience, you just Google the Equal Treatment Bench Book and you'll get linked through to a judiciary.uk website where you can see that in electronic form. It's a very interesting read, and one which I suggest is essential to all practitioners if you've not already done so. It's pretty lengthy, and it covers all sorts of aspects which aren't really relevant to criminal practice, but there are quite a few sections in there which are extremely useful, just to bring yourself up to speed with the modern way of approaching things, what with us being often labelled as somewhat out of touch. Now, the guidelines themselves follow the now familiar two-step approach with which we have all become familiar, let's face it. Step one, determining the offence category. That involves firstly an assessment of the offender's culpability and the harm caused or intended by reference only to specific factors which are set out in each guideline. Then you come on to step two, which is the starting point and category range. This applies to all offenders, irrespective of plea or previous convictions, and specify a category range for each offence category. Now, the guidelines provide non-exhaustive lists of aggravating and mitigating factors relating to the context of the offence and to the offender. And within this process, a judge has to decide on upward and downward adjustment from the starting point. All right, so we're all familiar with that. In some cases, in fact, it may be appropriate to move outside the identified category range when reaching a provisional sentence. So, under these new offence-specific guidelines, the assessment of risk when sentencing for possession of a prohibited weapon has been split into two issues. The first is whether a loaded firearm automatically means a high risk of harm, regardless of the circumstances of the case. The second is how judges assess risk based on events that may or may not take place later. That's something of a new departure. It sort of has at least a nod to Avis, but it has an effect also specifically when one considers custodians. It's been drawn up with them in mind also, and the culpability of vulnerable defendants was considered where they had been asked to hold a firearm for another. There is a potential for a significant difference in culpability for a person not knowing that it is a firearm that they're holding and knowing it is a firearm and that it is to be used in criminal activity. So it's important to note that the culpability factors were redrafted to include lower culpability where there is either no use or no intention to use the firearm. Now, also during the consultation, some respondents requested further guidance on what could amount to exceptional circumstances for not imposing the minimum term. This is the one that everybody's always keen to address. Now, the Sentencing Council said that there was some sympathy for those who wanted more specific guidance, but quoting them, as the test is one of exceptional circumstances, it follows that these cannot be defined, which is, of course, extraordinarily helpful. However, there is some help in step 3 of the guidelines, and there is also some very clear guidance as to what cannot constitute exceptional circumstances, so that door is firmly closed at step 3 in certain regards. Now, you can, I'm not in a position to share this with you. There will be no handout. I don't have the media reserves of Gwatkin and McGuinness, but the guidelines obviously are easily accessible on the sentencingguidelines.org.uk website. There are 8. They cover the possession and purchase, acquisition of prohibited weapons or ammunition, the possession and purchase of acquisition of firearms, ammunition and shotguns without a certificate, and various other offences, including carrying a firearm in a public place. There's another guideline for possessing a firearm with intent to endanger life. There's a separate one for possessing a firearm with intent to cause fear or violence, and so on they go. Now, we do not have time to embark on an analysis of all the guidelines, and so with the remaining time, I thought we could chart a course through one of the guidelines by taking a case study. This is where I'm going to need to screen share in a moment. Jess. So notwithstanding all the drop-down menus, you'll see that the days of choosing a spot on two perpendicular axes of a chart and running your fingers along them to the center in order to sink someone's battleship are not entirely over, but it takes a bit longer to get to the fun part. So let's take as a case study an anonymized real case that I prosecuted, in fact, last year. Police Constable Smith, no relation, was tasked to join a search for a suspect who robbed an old lady at knife point on an inner city housing estate. Okay, the officer entered the estate at about 11 o'clock at night. He saw a group of 5 or 6 young men, approximate age 20, early 20s, apparently hovering in an alleyway smoking spliffs. So Constable Smith recognised one of the men as Mr. X. They all ran away. And as he passes the point in Chase where these young men had congregated, he noticed a plastic bag, Sainsbury's bag, lying on the ground. When he opened it and had a look inside, he found a sock, and inside the sock he found a loaded Glock handgun with a barrel less than 30 centimetres. It happened to be loaded with 9mm parabellum rounds, and there was mixed DNA on the gun, suggesting that it had been through many sets of hands over time. This is a very familiar sort of story. The scientists match Mr. X to a combined swab on the handle, and they get the appropriate match probability, and there is a DNA match found for him. He's consequently arrested. He's 23 years of age, so he's a relatively young man. He's got form for possessing Class A drugs. 4 years ago, when he was only 19, he received a fine. He's had a few lucky escapes in the past. Now, he's charged with possessing a prohibited firearm. Of course, because of its length, it's a 5.1 ABA firearm under the 68 Act, and the ammunition is caught by Section 1, subsection 1B of the Firearms Act 1968. And so we have to look at the specific guideline, which I hopefully have popped up there. Bingo, there we go. Hopefully everyone can see that. So this is the specific guideline for possession of prohibited weapons. It's effective, we can see, from the start of this year. We can see that a Section 5.1 ABA is an indictable only offence. And we can see that the maximum is 10 years custody, an offence range of a discharge, no pun intended, to 10 years custody. So basically, everything is there that would previously have taken about 30 minutes, going from chapter 24 to chapter 11 to chapter 5, back to chapter 24 in Archbold. And we can see, if I hover the cursor over this little blue section, user guide for this offence, I'm not going to open that, but if you click on it when you're having a look, you get it takes you straight via hyperlink to the section which deals with the guidelines generally. Now, directly below, you see that the users, judges, are to be made aware of the deployment of the Equal Treatment Bench Book that I've already referred you to, and that it covers quite a lot of aspects of fair treatment and disparity in outcomes, which the sentencing tribunal should pay great heed. We see applicability. Well, I think everybody knows about that. That is Section 120 of the Coroners and Justice Act of 2009. Basically, the guidelines apply unless it is contrary to the interests of justice so to do. And if you click on that applicability section, it also takes you to the overarching principles of sentencing for children and young people, because of course, quite a lot of young people get involved in carrying firearms these days. Now, we are reminded there in the blue box that this offence is subject to the statutory minimum sentencing provisions, but as I've already said, but they are not taken into account until one gets to steps 2 and 3. Now, we come on then to step 1. which is determining the offence category. Now, it's worth remembering that this assessment focuses on the nature of the weapon itself, not whether the weapon is loaded or in fact in working order, which is, and remember obviously that references to weapon include component parts of the weapon. Now, as I scroll up, and we just pause here, we will see that our Glock has been charged under section 51 ABA. And if we click on the link, we can see that any firearm which either has a barrel of less than 30 centimetres length or is less than 60 centimetres in overall length, and so on and so forth, qualifies under this section. So again, this is brilliant. Just hours of flicking from page to page to page, all gone in a puff because of this guideline. And the more familiar you become with it, the easier it will be to chart your way through. Obviously, type 2, type 3 are offences which don't necessarily attract the statutory minimum, for example, of 5(1)(b) there. A type 3 might include a stun gun. Typically one comes across these days. So we've settled on it being a type 1 weapon. These guidelines are very helpful, but they are, to some extent, in my view, restrictive. You'll see in a moment. They give flexibility, but the hoops you have to jump through are significant. Now, we then come on to culpability, other culpability factors. They are divided into 3, high, medium, and lower. We're familiar from the other guidelines that we've all studied and use in regular practice. Let's just think about the example that we've got here. We've got Mr. X in his Glock, which is loaded with 9mm rounds. Medium culpability, firearm loaded or held with compatible ammunition. It's a case where it appears as though, let's just say the Crown can't really say much more than he was caught in possession as a custodian in relation to this gun, and no doubt that will be developed as part of the mitigation. So careful thought needs to be given to which category other culpability factors it falls into. But I'm going to say this is a type 1 medium culpability. You may disagree with me, but I've got control of the guideline. It would be a moot point, but this is merely a way of trying to help you navigate through this document. So we now come onto the battleship table, because we've got a type 1 offence and we've got medium culpability. So we take our line and we draw along and down, and we come to culpability category B. So let's just let's bank that, so to speak. This is a culpability category B offence. So now, as I scroll up, you see we have to go on to consider harm. Now, harm is assessed by reference to the risk of harm you see, or disorder occurring, and or actual harm or distress caused. The court's required to factor in location, whether individuals were exposed, such as vulnerable individuals, especially children, and accessibility and visibility of the weapon, and so on and so forth. In our fact-specific navigation, we've got it in a plastic bag lying on the ground, in fact, in somebody's front garden. And so as far as that is concerned, there is no alarm or distress caused. Let's say it's a category 3. So we've got a culpability category B, harm category 3. So we then come to step 2. As I say, these things become more and more complicated as they come up with more and more guidelines. But ultimately, it's a satisfying experience to go through this with some reassurance that you're not missing anything. But when we come on to step 2, the starting point and category range, again, there is a very specific reference to the fact that disparity in sentence, there's significant evidence of disparity outcomes for this sort of offence, which indicate that where the minimum term applies, a higher proportion of white offenders receive a sentence below the mandatory minimum term, and as a result, less severe sentences compared to Black, Asian or other ethnicity offenders. And when the courts do not find that the minimum term is appropriate to apply, or it doesn't apply per se as a result of the type of offence, there's a slightly lower proportion of white offenders receiving immediate custody as compared to Black, Asian or other minority ethnic offenders. So the court has been specifically referred to the Equal Treatment book. How exactly one addresses this is difficult, but I think it requires a great deal of sensitivity and acknowledging that people who come from disadvantaged backgrounds, who don't have necessarily the same access to education or the same role models, who perhaps are living on low to no income, are possibly more likely to come from ethnic minority groups, Black and Asian minority ethnic groups. And so this is why there's a disproportionate reflection. That seems to be the result of some of the research that was carried out in the consultation. Now, we come on then to tables 1 and 2. 1 is the table we use where it's a statutory minimum offence. 2 is for all other offences, which are not per se, which don't per se attract the minimum, or where you persuade a judge that this is an exceptional case, either on its facts or in relation to a defendant, and therefore the minimum sentence need not be applied. If you are successful in so persuading a judge, you look at table 2, not table 1. Of course, step 3 details how to approach that, and we're going to come to that in a couple of minutes' time. So, table 1, which is where we are for our Glock, and as far as table 1 is concerned, we're looking at a 3B, which is slap bang in the middle of my chart. Bing. Starting point of 6 years, starting point of 5.5 years custody, 5 years, 6 months, and a range of 5 to 7 years custody. So basically, the lower end of that is on the minimum sentence in any event. We'll gloss over table 2 to some extent, but you'll see if one is looking at maybe a stun gun type offence, it may well be that you can get yourself into a culpability C category 3, in which case, or even B, in which case you're looking at a fine or a community order, which has come as a surprise to some people who've recently had cases involving those sorts of prohibited weapons. Obviously, if you're looking at category type 2 table offences, fines are a consideration, as are community orders, and there are drop-down menus for that. There are also drop-down menus in relation to custodial sentences, which is, of course, we are concerned with our statutory minimum 5 for our offender who's 23. And if we click on that, we just see the standard questions which a sentencer is asked to consider. Has the threshold been passed? Is it unavoidable to impose custody? What is the shortest term? And can a sentence of a suspended sentence be imposed? So those are the classic questions which we are all familiar with. Now, we then come on to factors increasing seriousness. Previous convictions. Again, if you were to click on the underlined section, it would take you to the statute. I'm not going to do that, but it would set out exactly where that is set out. In essence, in this case, 4 years ago when he was 19, possession of a bit of Class A, bit of coke or something, received a fine. It's not really relevant to the circumstances of this offence. It was a few years ago. He was a younger man. Although he's not a man of previous good character, I would suggest that it's something which the court isn't going to pay a great deal of heed towards. Offences committed as part of a gang, well, nobody can really say that that necessarily is the case here. If they had been out supplying drugs, for example, that might have been a different situation, or if there was a robbery or something of that sort. Factors reducing seriousness or reflecting personal mitigation. Here, good character, not applicable, but you can see here, held on behalf of another through coercion, intimidation or exploitation. That is a classic chestnut which just about everybody seems to run in mitigation, but there we can see it's acknowledged as a specific factor reducing seriousness if the tribunal accepts it. And so we come on now to the minimum terms, which are contained within the provisions of section 311 of the Sentencing Act and Schedule 20 of the Code, which, as I've said, 5, 18 and above, 16 or 17, 3, below 16, it doesn't apply. And there are a number of things to note. One is, obviously, that there is no reduction below the 5-year term for plea. So even though you may have got a plea in nice and early, I'm afraid you're not going to drop below 5 or 3, unless you satisfy the judge that this is an exceptional case. Where the minimum terms applies, this should be expressly stated, so the judge has got to say that. In terms of where their exceptional circumstances are argued, if it's the case that somebody is disputing the basis on which they're entering their plea, then of course that would call for a Newton trial. That's again in the Criminal Procedure Direction 7, Sentencing B. I mean, there seems to be a direction for absolutely everything these days. And where exceptional circumstances are found, or indeed not found, that has to be expressed in the sentencing remarks so that the sentence can be understood. But here we go, principles. The sort of catchphrases that you're going to be looking for if you're defending and you're trying to argue exceptional circumstances are things like arbitrary and disparate and disproportionate, truly exceptional. You can persuade a judge to that effect. And also it's worth bearing in mind that a single striking feature might qualify for exceptional circumstances, or a number collectively. But what they have specifically excluded is one or more lower culpability factor, the type of weapon falling in type 2 or 3, one or more mitigating factors, or a guilty plea. So don't even waste your breath in trying to argue those, because that will get you nowhere. But where there are exceptional circumstances found and the judge has so declared, then of course it doesn't qualify for the statutory minimum, and there you would expect to see some credit for your plea. It's also worth remembering that if the judge does find exceptional circumstances, the table that the judge is invited to look at is table 2, not table 1. So you get yourself into that lower table, and for an A3, it's suggested that you take it as a culpability A. For an A3, the starting point would be 1 year's custody. That is 4.5 years less as a starting point, with a range of a high community order to 2 years. So maxing out at 2, which is going to make a dramatic difference for your lay client. Now, as for sentencing offenders under 18, in those circumstances, I've already touched upon that. You look at the overarching principles of sentences for children and young offenders and take into account the lower starting points, depending on the age, as a percentage of what an adult would ordinarily qualify for. Now, in the process, we then go on to step 4, I call the grassing provisions. If you basically coughed to the authorities and you've assisted in an investigation or provided worthwhile information, then it's a brown envelope round the back. And a nod as good as a wink, but that would entitle you to a reduction thereafter, but not below the minimum if that were the case. Guilty pleas, as I say, as we all know, that's got its own guideline of itself, but of course, as appropriate, one would apply a reduction if either it wasn't a minimum case or an exception was found. So that would allow for a reduction. And then we look at totality. Now, before I go on to totality, of course, the judge has got to sentence Mr. X for the possession of the ammunition. So that's got its own guideline. We're not going to go there, but there's a guideline entitled Firearm Possession without certification, and that covers the 9mm parabellum rounds. There's only a handful, so it's a small quantity. So it's type 3. Lower culpability, because of course he had no intention of using the ammunition, so it's culpability category 3, and for harm, I would say, on following the analysis I've already applied, it would be a category 2, and frankly that would be a starting point of a medium level community order, somewhat surprisingly, with a maximum of 6 months custody. So whatever happens in relation to that, applying totality, the judge is either going to pass a concurrent sentence or no separate penalty. And then, of course, we come on to ancillary orders. It's not over just yet. That usually means destruction and forfeiture of the firearms or cancellation of a certificate. Serious crime prevention orders have to be considered depending on the circumstances. Then the judge has to give his or her reasons, which have to be set out. And this is where, again, the equal treatment bench book comes in, because that tells judges that they basically have to address the defendant or defendants in language that he or she is likely to understand. So off the high horse and try and speak to somebody in a way that they can understand, rather than simply saying, well, there you are, your counsel will explain it all to you when he comes to visit you in the cells. So I nearly said members of the jury there, but it was the first time. That really is something of a rapid tour de force of one guideline. I hope that it has been informative. I would hope that it has inspired you to go away and have a look at the guidelines. You certainly should. These don't often come up, but when they do, they're complicated. And when you get a late return, it's difficult. These guidelines are also going to make the prediction exercise so much more straightforward. When one is advising lay clients, and when they're young and they've got their parents there or some other member of the family along, it just gives that certainty, a greater degree of certainty. You can explain to people where you think it's all going to fall in the guidelines. And so there's some measure of reassurance, rather than simply going in there and saying, well, I've got to answer the 6 questions and I think it's going to be worth about X. So hopefully this will promote some consistency. Hopefully you have found my talk informative and helpful. My sincere apologies if I've just wasted 30 minutes of your time, but it has been 30 minutes of your time. And I can see that the Secretary of the Parish Council is just about to close me out of this meeting. So thank you very much indeed for listening.
Well, before you all dash off, I just want to say a huge thank you to David, John and James for the talk today, and to thank you all for coming and giving up an hour of your Thursday evening to the inaugural Foundry Chambers lecture series. And I'm sure the fact it's CPD qualified has absolutely nothing to do with your attendance tonight. And I look forward to seeing you in April, where the topic is going to be modern slavery. Thank you all so much for coming, and thank you to our speakers again. That was brilliant.
Thank you.